The opinion came out October 3rd, 2013, which addressed that issue. I will also tell you that the right to a jury trial, even in civil cases, is not an absolute right. And I was able to find 2 examples of where a jury trial is not allowed in a civil case. First of all, divorce cases. Divorces are by nature a civil lawsuit. There's no right to a jury trial under Oregon law. Small claims trials. Oregon law has said that any claim for under $750 is mandatory small claims, and there's no right to a jury trial in a small claims action. I'm not saying that's right or wrong, but that's the law that as I understand it, and that's what I'm bound by. Certainly, and that can be a basis for an appeal, and again, I encourage that. Another argument you raised referenced that I was acting as both judge and prosecutor. I want to make it clear that I'm not. I'm merely the judge in this. The prosecutor is, in effect, the officer. He is...
Did you have proof of corpus delicti as their injured party?
Can you clarify your question, please?
The phrase corpus delicti is generally is used to mean a physical object upon which the crime was committed. Again, this is not a crime, so therefore there is no...
Then what am I being punished for? If there's a fine imposed on me, then there has to be, he has to have a lawful claim. He can't just say, oh, I didn't like where your plate was, so now you owe me $300.
No, he's deemed, in his opinion, that you have violated Oregon statute in 2 different ways. He has made that allegation, and he's been empowered to cite you into court on that violation. Let me finish, okay? He then comes in, and the way our system works is you certainly have the right to refute his allegations, and that's why we're here today. The officer has the burden of proof by proving by preponderance of the evidence whether or not his statements are sufficient and are more likely than not accurate. You then, if he has done that, and he has at least established his burden, the burden then shifts over to you to prove that, in fact, you did have the license plate properly. Hold on, let me just finish and then we'll talk. The burden shifts to you to prove that you did have the license plate properly and adequately displayed, as well as you did have proof of insurance with you. If you're able to establish that, so one of 2 things happens. Either I can't decide who's right and who's wrong, you win, because he has not then established the burden of proof. If I find that more likely than not you're correct and he's wrong, you prevail. But that's kind of where I'm dealing. So the corpus delicti doesn't apply, and me acting as judge and prosecutor isn't accurate because I'm not acting as prosecutor. That's the officer is acting as prosecutor. He's presenting the case. I'm merely making the factual and legal determinations based upon the evidence that I hear today. Okay, so I want to address that. And we can certainly, if I can, if you don't mind, I'd like to jump on. You also referenced the denial of due process under the Fifth Amendment. And again, that I'm going to tell you that applies to crimes. And under current Oregon law, this is not considered a crime. It is considered a non-criminal violation. And therefore, the Fifth Amendment wouldn't apply. Just seeing if I'm getting any other notes. Oh, there's also something you had referenced in, with me acting as judge and prosecutor, you referenced 18 U.S.C. Section 208. That applies to administrative hearings, and that essentially, actually it only applies to federal employees, and then it bars acts affecting a personal financial interest. Again, I'm not a federal employee, and I don't have a dog in this fight. I get paid whether I'm here for trial, or I get paid whether you plead, whether you fight this. It doesn't matter. I essentially really do have no dog in the fight. Then you referenced lack of jurisdiction under 5 U.S.C. 556. That's the one that references administrative hearings and judicial proceedings after the opportunity for administrative hearings. So that's not an applicable statute. Okay? That's kind of just going through my notes in response. Do you have any, and then you talked about a bill of attainder.
Right.
And I'm finding that this is not a bill of attainder, because the definition of bill of attainder is essentially a legislative quasi-judicial act. It's an act of legislation which singles out a particular individual and punishes them without an opportunity for a hearing or a trial. And that's Marbury versus Madison, where they said, the legislature, you can't do that. That's a judicial function, and that is the determination of whether someone has violated a law comes before the jury. So a bill of attainder doesn't apply here because in this case, the law has been set out that says this is what you need to do and this is what you can't do. And in this case, it specifically talks about a proper display of the front license plate, and it talks about requiring proof of insurance. They're not, and they set the potential fines, but they don't say, you know, the officer can't write you a ticket and you have to pay that right then and there. You have due process, you have the right to a trial, which is why we're here today. Okay? So on those issues, would you like to discuss them further?
Yeah, statutes don't apply to traveling. They only apply to drivers.
Okay, I'll disagree with you on that.
I wasn't driving. That's the thing. I was just simply traveling. I was just watching Hyson on his duty.
Okay.
If I was driving, then I would have been transporting goods or services for some kind of money form or property or some kind of exchange, which I wasn't doing.
Okay. I understand your argument. I disagree with it, though. Okay, driving and operating are the distinction, as far as I'm concerned, is operating. You can be sitting in a car while it's idling, and you're still operating that vehicle, but you're not driving it. In my opinion, you're driving it if the vehicle is actually moving. So that's how I define it or differentiate between operating and driving. I am finding as a matter of law in my court that it doesn't need to be for commerce, it doesn't need to be, you don't need to own the vehicle, you don't need to be getting paid to transport anything, okay?
Right, but I still have the right to travel in my private conveyance. No court can overrule that. It's a natural right that was given by my creator.
Okay, I will disagree with you on that on a couple of different bases. You certainly have the right to travel. You can go from town to town, state to state, country to limitations as far as country to country, but certainly in the United States, you can travel town to town, state to state. There are limitations where you can go. For example, I can bar you from coming onto my property. The government can bar you from coming onto their property. So there are limitations there. As far as operating or driving a motor vehicle on public highways, there can be limitations, and there are. If Oregon law has deemed that driving on public roads is deemed a privilege, the right to travel may be unfettered or limited fettered, but maybe almost essentially an absolute right. The right to use public roadways is not an absolute right. That is a privilege granted by the state.
It's actually a right because the gasoline tax pays for the roads.
Well, they don't pay for all the roads, but yes, okay. Even accepting that argument, it's still processed through the government. And therefore, Oregon has deemed that the right to travel on public roads is not a right but a privilege, which is why they...
But the Supreme Court has ruled to the contrary.
I disagree with your analysis on that.
It's right here, Shapiro versus Thompson.
Okay, and sir, I'm just telling you, I'm respectfully disagreeing with your analysis of the case law, okay? That's why they have appeals. By the way, did you have an opportunity to remember what you wanted to ask the officer?
I didn't.
Okay. Do you have anything further you'd like to add? Let me just ask you, do you have insurance?
I'm not lawfully required to have, so.
Okay, and the reason I asked...
At the time I did, but
okay.
I'm just saying though.
The reason I asked that is King City, we generally have what's called a fix-it ticket, which is if you do not carry proof insurance with you, but you do in fact have insurance, and you bring in proof that you had insurance at the time, generally we reduce or essentially dismiss that ticket as kind of a courtesy to the people. I want to let you know that. So if you have with you today proof that you had insurance at the time, I'm willing to write off that ticket or reduce it down to $25. But other than that, I'm going to have to rule on both violations. But I certainly want to give you the opportunity to tell me anything else.
I'll definitely appeal it.
Okay. And I would ask one favor of you. When you appeal it, if you would copy me, and I'll give you my personal business card. And again, I'm curious. I find what you're doing to be intriguing. I'm not sure I would have the time or the inclination to fight this battle like you are, but it still interests me. And to the extent that I can learn more, I'm always open to learn more.
Yeah, definitely.
Okay, so it's a request, rather. It's certainly not, I can't order you and I wouldn't order you that. Do you have anything else you'd like to add?
No, I think that's it.
Okay, officer, do you have anything further you'd like to add?
I do not, Your Honor.
Okay, based upon the facts and evidence and legal arguments introduced today, I'm going to find Mr. Carver guilty on both of these violations. Carbon paper.